Good evening, ladies and gentlemen. My name is Richard McDonald. I'm not a citizen of the United States, and I'm not a U.S. citizen. I'm a Californian, as described in the Federal Style Manual, Section 5.23. There it states that when identifying a native of one of the states, the proper definition for a native is a Californian. If you're from Texas, it's a Texan. Federal government has recognized there's such things as state citizens. And this is basically what I do, is try to teach everybody to be like George Washington, Ben Franklin, state citizens. They were not U.S. citizens either. They were all state citizens. George Washington was a citizen of Virginia. Benjamin Franklin was a citizen of Pennsylvania. Knowing the legal distinction is where it comes about, where you understand the law. Everybody heard of the slaughterhouse cases. It's one of the most famous cases that's quoted all the time. And I'm going to read everybody. This is an 1873 court case. And this is what the United States Supreme Court said in 1873, after the 14th Amendment. It has been said by eminent judges that no man was a citizen of the United States except as he was a citizen of one of the states composing the Union. Those, therefore, who had been born and resided always in the District of Columbia or in the territories, though within the United States, were not citizens. So if you're a citizen of the District of Columbia, what does it say? This is after the 14th Amendment. You're not a citizen. What are you? You're a person. And write this site down for those who haven't been here in a while. There's quite a few strange faces around tonight. The court case is U.S. versus Otherson. Otherson. 480 Fed Sup. 1369 at page 1373. All federal law only protects aliens, foreigners, and persons, not citizens. So no federal law applies to any citizen because it can't protect them. The laws of Tokyo, Japan can't protect me because I'm not a citizen of Japan. Only the laws that can protect you, you are subject to. If you're not subject to the law, then they can't protect you. The laws of Argentina can't protect me. That's what the court said. That's the 1979 Federal District Court in San Diego. So once you understand the meanings of the words, which is very crucial. And one of the key things that I've been working on for 2 months now, I had to take last month off. I had to sweep my floor twice because it got flooded twice last month. Mud, 2 inch thick the first time, 1 inch thick the last time. El Nino got to me. But I've been working on doing a new Patriot newsletter just on the words resident. How many people here understand the true meaning of the word resident? You're better than I am. There's 758 different meanings of the word resident.
That's my true meaning, not yours.
There's 758 legal meanings of the word resident. I can be a resident of a city, but I'm not a resident of the state. A resident of the city means you live in the city. When you say you're a resident of the state, that means you're alien to the state. You're just like an illegal alien that comes over from Mexico or Saigon or China or England, Russia, whatever. Makes no difference what country. When you come here illegally, you're a resident because your allegiance belongs someplace else. That's what the resident means when you say resident of a state. It's a very narrow term. Goes all the way back. I have a old law book, Vattel's Law of Nations. That's where they come from. The federal government, when they write these laws, they write them legally correct. They're not enforced that way, but I mean, that's where they get you to understand that the meaning of the word citizen of the United States. Are you a citizen of the United States? No. I could be. What do you mean you could be? Well, if I left here and went to Guam, as a state citizen, I would become a citizen of the United States, you know, in the territory. As a consequence of being a state citizen, the federal government would have to protect me in Guam. But as long as I'm within any one of the 50 states of the Union, the federal government cannot protect me. My state constitution does. Most people don't understand that. They think the federal constitution is almighty. It's not. It's very easy to prove. And I love proving things to people. The state's constitution is far superior than the federal constitution. Because the state constitution was written before the federal constitution. Go back in history. When I turned 21, that was back in the 1700s. We wrote a state constitution. Then we declared war on England. And in 1776, and then beat them, kicked them out. And there was only 3% of the population actually fought England. The rest of the 97% were all a bunch of wimps. You fight the battle for me, I'm gonna stand back, and when you win, I'll join your side. You lose all your blood, and when you get all your bruises and your nose bloodied, and when everything's done and over with, then I'll join your side.
Free rider.
Free riders. That's the same thing today. So, we fought England, kicked England out. In 1783, write that date down, 1783, Benjamin Franklin went to France, and there he signed a Treaty of Peace of 1783. It's called the Treaty of Peace of Paris. You can get it at the law library, and get it almost any place. There the King of England relinquished all his sovereign powers over the land and the people. People were sovereign, 1783. Absolute sovereigns on their own land. They were just like midget kings, minor kings. And man's home was his castle. That's where the term came from. Then the people got together and said, hey, we need a form of limited state government. So they wrote a state constitution. Then the states got together and said, mostly it was North Carolina and South Carolina. One had pink money and one had green money, and neither one would accept the other. You know what I mean? There was a bunch of conflicts over that, you know what I mean? This one didn't want to accept their money, you know what I mean? Your money's over there, you know what I mean? They said, hey, we got to have something, organization here so we can go from state to state without all this problem. So the state governments got together and wrote the federal constitution. Then they gave it to the people to ratify. Because the state has no power to ratify the Constitution. They gave certain powers that the people would give to the states, they gave to the federal government. Upon giving this power to the federal government, they said, okay, people from all the 13 colonies, we want you to ratify this U.S. Constitution. And the people looked at it and said, huh, I don't like this. We want to amend this. We want to put new articles in addition to. There was no amendments. They hadn't been ratified yet. So you can't amend something that's not in existence. So they wrote articles in addition to, commonly called the Bill of Rights. They're not amendments. The 11th Amendment is the First Amendment. That's legally correct terminology when you use it. So they wrote this article in addition to further restricting the federal government, saying, thou shalt not, thou shalt not. That's what they did on the Bill of Rights. They were scared to death of the federal government. They were afraid the federal government was gonna come out and take your firearms. They were afraid the federal government was gonna come out and take your due process rights away. Which they did. In 1868 when they did the 14th Amendment. And this remained true all the way up. And that the federal government was not authorized under the Constitution to have its own citizens. The federal government was not authorized to enter into any state of the Union. They had no police powers with any state of the Union. They could not make an arrest in any state of the Union. The federal government wanted to arrest him for violating one of the federal laws. They had to go to the local sheriff with their complaint. The sheriff would go to the judge, the local state judge, and there, the state judge says if it was valid, he would sign a warrant for his arrest. They had no power. Several states refused to allow federal agents within their state of the Union. But then along came, in 1868, along comes the alleged 14th Amendment. I say alleged for a simple reason, that's never been ratified. And why hasn't it been ratified? Because in order to pass it, they shot 2 senators going into the Senate House, and the vote was tied, and they excluded a whole bunch of states. And when the vote was tied, they took off one senator who voted against it, chair and all, and took him out in the hall and threw it out, locked the door so he couldn't get back in, and voted it in. Now that's properly ratified. There's a whole bunch of law review articles, history books on it. They all know it. How it was improperly put into law. But that allowed the federal government to create a citizen of the District of Columbia under the 14th Amendment. Then how did we all get in to be called a citizen of the United States under the 14th Amendment? 2 things were required for you to do that. It says all persons born or naturalized within the United States, not these United States, the United States, singular, and subject to the, which is singular also, jurisdiction thereof. So prior to 1935, the federal government had no power. So how did they get this power over us? Very easy. Social Security. Very simple. Got numerous court cases saying there's no law requiring anybody to have a Social Security number. 1924, guy went down to Mexico City, opened up a business, made some money. He was a resident of Mexico. A citizen of the United States, a resident in a foreign country, Mexico. Was charged income tax. 1982, U.S. versus Slater. Can't remember the site. 1982 Delaware court case. They said the man was a resident of Delaware, a foreign country, and therefore he had to pay the tax. Quoting the Mexican cases they're authority for, 1924. So you as a U.S. citizen are being treated as if you are in a foreign country. He was under the protection of his passport in Mexico City, and you're under the protection of your internal passport, which is a Social Security number. Yes?
Richard, the fellow in Mexico, did he file a 1040 form or the equivalent at that point and just not declare the Mexican income? Or,
No.
or didn't even file?
Didn't even file. But they came down and got it. Because he was under the protection of the passport. And you, as a U.S. citizen, are under protection of your passport, which is in terms your Social Security number, which allows you to work. And under protection, this is why OSHA, Social Security, SDI, and all the rest of them, they all tie you into the federal government. I'm not eligible for any federal benefits at all, except I'm not a U.S. citizen. That's Revenue Ruling 57-572. See, our main fault we all have, and I'm just as guilty as the next one, is we're all ignorant. Ignorant of the law, per se. Because I was so busy chasing girls and when I was younger and working hard to make a buck, you know, to keep a roof over my head, support my wife and kids, and I didn't watching the boob tube, you know what I mean? They had me entertained, you know what I mean? And I didn't have time to think of anything. Until they stepped on my toes. Once you step on my toes, you step on the wrong toe. Then I started researching to find out why. And I found out the federal government has very, very little authority. The federal government can't even give you sovereign immunity. You know, U.S. attorney, they got the show on about the U.S. attorney, this red-headed guy, what's his name? On TV now?
Michael Hayes.
Michael Hayes, U.S. attorney. He can't give anybody sovereign immunity. You know why? He doesn't have the authority. He has to go to the superior, which is the Deputy Attorney General of the United States. Now, he is the constitutional one. Michael Hayes is the same as the Attorney General of California. They're same as, what's his name, the Deputy Attorney General you're working with?
My guy, Vladimir Shelkovich.
This Russian guy, Shelkovich. The U.S. Attorney is on the same level playing field as the Deputy Attorney General of California. He's got to go to the boss, get grant sovereign immunity. It says so right in their law books, but nobody wants to open up the law books to read it. They all say, hey, Michael Hayes, he's the most terrific guy in the world. Brainwashing. And American people are the greatest people to be brainwashed because they got an interesting show going on, they're going to watch it. And they get it brainwashed, you know what I mean? What's the other? How many people have seen Dawson Creek? New show. Nobody here. I haven't seen it either. I just heard about it. I don't know. But I do like Buffy the Vampire Killer. I like science fiction. But see, brainwashing, that's what it's all about. Get you interested in something else. And a friend of mine made this up for me. If you focus on this. You ever read that? Call me a Californian. Don't call me a U.S. citizen. It's important that you understand what the difference is. The Californian sovereign. U.S. citizens are slaves. Very, very easy. Got a whole bunch of court cases along that. And this week I finally finished this other motion. One of my pet peeves is the DMV. The code enforcement in the courts. I love the courts. I finally finished this new judicial notice. How many people here have heard the Nuremberg trials? You know what Hitler's Gestapo said when they got up on the witness stand? He says, I was merely doing as I was told. I didn't understand what I was doing, I was just doing as I was told. How many times have you asked a police officer on the witness stand, well, what is your definition of motor vehicle? Immediately the prosecution would jump up and say, objection, Your Honor, the officer doesn't have to know the meaning of the words. And the judge says, you're right, sustained. I'm going to stop that. And in fact, when this starts, judicial notice gets sent out through the court system, they're going to change the academy from 6 months to 1 year. All policemen are going to have to go to school for 1 year now. Academy, because they're going to have to learn the law. Very simple. And I'll read this to you. Notice is hereby given that on blank day of blank 1995 at 13:30 hours, or as soon thereafter as matter can be heard in the courtroom, etc. blank, will move the court to enter this notice as evidence and take judicial notice of the unavailability of the Nuremberg type of defense. This judicial notice will be based upon oral arguments and the reports from authorities attached hereto. Now write these cites down as I give them to you. It is a well-known established fact that prosecuting attorneys objects to each and every question to the police officer in regard to his knowledge of the law as it relates to the citation he has given. This is in fact wrong in that the officer must know and understand the law so he can properly enforce it. Thus, the use of a Nuremberg-type defense, I was merely doing as I was told, unquote, would be extremely prejudicial to the accused in this instant case. The officer must know and understand the laws that he is enforcing, which includes the legal meanings of the terms of the law as is being enforced by him. Failure of the officer to fully understand the law would be a denial of due process and in violation of the numerous court decisions which have held that an officer must know and understand the laws he is enforcing. With first cite, Henry McGowan, M-C-C-O-W-A-N, 177 C-93. This is what the California Supreme Court said. Ignorance of the law does not excuse misconduct in anyone, least of all in a sworn officer of the law. Here's another one. San Francisco versus Linnard, L-I-N-N-A-R-D. 98 Cal-Appellate 33. 98 Cal-Appellate CA 33. All are presumed to know the law. It's a presumption that you know, understand the meanings of the words. If you don't, you better object right away. Next one. Daniels versus Dean. D-E-A-N. 2 CA 421. 2 CA 421. It is a fundamental maxim of the common law that ignorance of the law excuses no one. Okay? Now here's an old one of 1993. People versus Morse. Citizens are required to apprise themselves not only of statutory language, but also of legislative history and underlying legislative purpose. And the cite on that is 21 Calat 4th, 259. Repeating, 21 Calat 4th, 259. And went to the United States Supreme Court and they upheld it further. Now here's the federal court saying the same thing. Mahan versus City of Largo. M-A-H-A-N-H-O-N versus City of Largo. 1993. Fed Sup 377. 829 Fed Sup 377. With respect to the officer's testimony, numerous courts have held that a police officer has the duty to know the law he's empowered to enforce. The officer has a duty to understand the law. And if you don't understand the law, then he's in dereliction of his duty. And my clinching paragraph on this thing is what I like best. In conclusion, the court is respectfully requested to deny any objections voiced by the prosecution that falls within the guidelines of a Nuremberg-type defense. So this stops the officer from, see if he, as they did in Steve's case here, his police officer was, CHP officer was excused from the witness stand as incompetent to testify. And if he's incompetent to testify, how can he write a ticket? not competent. And he was very unhappy. 24 years on the force, and he's testified in 10,000 cases, now he's ruled incompetent. Once you understand the laws, you can move. That's what I'm trying to do, is teach you the laws so you'll understand them. How many people are human beings in the room here? We got a human being in here? Yeah, we got one right there. This is Valentine's Law Dictionary, 1948 edition. When you look up 1948, which is in this century, I didn't go back too far. You know what I mean? Look up human being, it says monster. And I'll read you the definition of this one, then I'll take you to why it's done. It's done for a specific reason. Okay? Where is it? Monster. A human being by birth, but in some parts resembling a lower animal. A monster has no inheritable blood and cannot be heir to any land, albeit it be brought forth in marriage. But although it has deformity in any part of its body, yet if it has human shape, it may be heir. And that came from Blackstone's commentaries of 15th century. And where did it come from? Why? It's very easy. You have to go back to the Bible. That's where it came from. The Bible relates to three specific things: man, woman, or citizen. That's all you'll be. There's no human being listed in the Bible. So when it happened back in the 12th century, when the Crusades died, when the knights and the kings and princesses were going across Europe on the Holy Crusades, you know, and they fathered a few children along the way. So to keep those children from attaining the throne and taking the land from the family, they call them human beings. So they don't have the right to inherit the land. So when they say you're a human being, that's the biggest deal, but they're calling you a second-class monster. And the government uses that term, human being, all the time, because they know what they're saying. It's just that we have been ignorant because we haven't gone to the law books to find out what they're saying. And I have a judicial notice on that. I made another judicial notice, didn't have to bring it with me, didn't need it. Saying, it's the court, take judicial notice that I'm not a human being. And quoting this. And if they refuse to accept and call me a human being, then I'm going to get judged for slander from the bench. Then I'll ask him, Your Honor, are you denying my judicial notice as it relates to human being? And they say, yes, I am. Your Honor, no offense taken, but I want the record to reflect I'm being slandered from the bench in open court. And once I've been slandered from the bench, the judge is no longer acting in his judicial capacity. I respectfully request you recuse yourself. There's no name calling allowed in court. Once you call it to their attention, you know what I mean? They got to go along with you.
You got the paper up on TV being ready?
Yeah, it's all been ready for a long time. Had it when I was down in Texas visiting you. And here's the federal government. Remember I said when I introduced myself, I said the federal style manual? They call it a culture style manual printed by the United States government, printed in 1984, which is a book about that thick, which they give to all the government agencies who write laws, and telling them how to use the words and what the definitions mean for the laws. And when you go to section 5.23, it specifically says, in designating the natives of the several states, the following forms will be used, not shall, will be used. Alabamian, Alaskan, Arizonan, Arkansan, Californian, Coloradan, Texan, you know what I mean? When they want to refer to you as a state citizen, this is the term they must use. Now, how many people have seen a law that says Californians are specifically identified in that law? Not even California makes a law that says that, because they're specifically excluded from the law.
What is somebody from Massachusetts?
Massachusetts, okay, let's see, what do they call it?
Stater? It couldn't be Massachusetts.
Massachusetts, Sam.
Really?
Yes.
That's what it says right there.
Oh,
They got the federal style manual. You can get it from the federal government printing office, GPO downtown, or you can go to any law library and just tell me what's the federal style manual, and it's right there, section 5.23. So you have court take judicial notice that I am a Californian, and therefore California is not specifically listed, and identify yourself according to the federal government. The next one you can use. There's two sites from the federal government that identify you as a state citizen. The other one is Title 8, United States Code, Section 1101, A, 21. United States Code, USC, 1101, A, 21. That identity. A national is one who owes allegiance to a state. I'm a state national. See, you got specific terms. That's the Immigration and Naturalization Service has their own term for it. Yes.
Or registry.
Department, they recognize that too,
Sure they.
because they sent me a letter stating, because I registered as a non-US citizen, California citizen, they sent me a letter if I fill out a form, I am a US citizen, I am not, and they said if I don't respond to that form, they're gonna investigate me with the DA's office. So I sent Richards 2 sites on that. I said I am a state national, namely California. I'm a California state citizen. Then I didn't hear from them for a couple months. I called them up. I said, what's the status of the paperwork I sent you? She says, oh, you're still listed on the rolls. I said, how am I listed? She says, well, you did not say you were not a citizen. She didn't say U.S. She just said you did not say you were not a citizen, so therefore you're still on the rolls. I said, so I'd like a letter to the effect that you liked my paperwork. She says, well, we really didn't like the paperwork, but it's sufficient.
Of course, they don't like it when you tell them the truth. When you use their laws against us. Heretofore in the past, which I'm just as guilty as the next man, in fact, I'm more guilty than the next man, of taking the rocks in my wheelbarrow, thrown into court, say, I'm going to prove the law doesn't apply to me. No more. I don't do that anymore. I've taken all the rocks out of my wheelbarrow. I learned their law. I researched it. I studied it. And I put all the rocks in their wheelbarrow. And I stand over there and not prove it. They can't prove anything. But first they got to prove them a person, which you can't do. Then they got to prove them a human being. Then they got to prove I got 5 legs and 3 heads, and I was born on Mars. Then once they get past that, then we can address the issues.
Now that covers those particulars.
That's one of them. There's a whole bunch of different things. There's not just one specific document there. There's 15 different types of documents, you know.
To begin with.
You do a whole bunch of different things. And here's an old book of, I think it was 1966. No, 1950. Sorry about that. This is an old book of 1950. Maybe this was the year I was born, I'm not sure. My mother told me. This is called, where's my first page on this thing? It's a about Reginald Parker's Citizenship book. And here, this says, part 3, privileges and immunities. Listen what they say. When one recalls the principles of dual citizenship in the United States form of government, there is no difficulty with the privileges and immunities clause of Article 4, Section 2, Clause 1, and the Article Amendment 14, Section 1. The latter, the 14th Amendment, protects a United States citizen against infringement by a state of his rights as a United States citizen. And the former protects a state citizen against infringement by another state of his rights as a state citizen. The rights are separate citizenship are inherently and definitely distinct. It's a book. I lost my first page of the name of the book. And this, the case that says this is Maxwell versus Bugbee. 250 U.S. 525. Repeating, Bugbee. Maxwell versus Bugbee. 250 U.S. 525. At page 538. So they're separate and distinct. They're always consistently telling you this. They keep saying this over and over and over again. But we collectively, I'm just as guilty. I can't say anybody else can't say they're not guilty because we're all just as bad. But I've learned to read their laws, and that's what I'm about, is to teach you how to understand their laws. Because once you understand their laws, you're that much smarter. Now they can't do anything to you. They're totally ignorant. Most of the people who work for the government are good people. They're merely under the Nuremberg defense type system. I'm just doing as I was told. Don't you understand the law? No, because they won't let me read the law. I've had IRS people tell me that the lower people are not allowed to read the law. They're supposed to do as they're told, keep their mouth shut.
It's only dispensed on a need-to-know basis.
It's dispensed on the need-to-know basis. I've had them tell me that. Some of the district director doesn't understand all the laws because it's on need-to-know basis. He don't need to know.
What a country.
Great country. And lately, I've been on Discovery, working on bills of particulars, you know what I mean? In Discovery and requests for admissions, okay? I'm going to give you a few samples to let you give you an idea how to do admissions. Anytime you get a traffic ticket or you're charged, Phil? Okay. Anytime you get a traffic ticket or you're cited in the court for a zoning or code enforcement violation, or any type of violation whatsoever like that. Or maybe purely an administrative, maybe they want to summons you in for an administrative correction. They want to take you in there. You have the right to due process and the right of discovery. So you can go in there and you file admissions right off the bat. This particular one I have in my hand is for a driver's license. Say you get cited for not having registration plates on your car. No license plate. Good charge. I like that because I travel around in my car with no plates. This is the way you make your admissions. Admit that the Revenue and Taxation Code, Section 10751, is the authority for highway use taxes. You go read the law, and that's what it says. You ask them to admit that. They say yes. Then you ask the next question. Admit that the Revenue and Taxation Code is the authority for requiring registration fees. Got several court cases say it is. So they say yes to that, okay? Admit that the Revenue and Taxation Code, section 100751, is a commercial use taxing statute. And so it says right in the statute, it's a commercial use. Okay? You gotta admit to that. Now you got them. You're walking them off the bridge, now they're getting ready to fall on their own sword. Admit that Revenue and Taxation Code, section 10751 applies to all commercial vehicles. They admit that. Now here's the clincher. Admit that Revenue and Taxation Code, section 10751, is derived from the 1913 Vehicle Code, imposing a license and registration fee on the commercial use of the highways. That's the in-race tort case. All others are exempted. So once you get them, you know what I mean, to admit all this, you got them off the hill. Now they can't backtrack. If they deny this, then they're committing perjury. And you make them sign it under penalty of perjury. You do everything under penalty of perjury when you do your admissions. That's for a driver's license. That's a similar type question. You read the law and ask him to admit the law. Now see, so you're going into federal district court. Say you want to sue the Internal Revenue Service. You can lose, but I can show you how to have some fun while you're doing it. You get a lot of good admissions out of them that will let you win. Admit that Congress is located in the District of Columbia.
Admit.
Admit. Admit that the District of Columbia is legally referred to as the United States.
Admit.
Admit that the United States Attorney cannot and does not represent the Attorney General of the United States.
Admit.
That's what their law says. Now here's the clincher. Admit that the United States Attorney only represents the Executive Department. Enforcing executive laws. Admit. See, you see, you read their laws and you ask them to admit it. You got a code enforcement case? Admit that the term residential means commercial. Admit that this is a commercial use of a building. Admit that the code enforcement is based upon protection of the public. Admit that code enforcement rules and regulations do not apply to private homes, non-commercial private homes. You know what the term resident means? Residence, that's a business address. It's a legal business address, is a residence. Very easy to prove. When an ambassador goes to France, there he has a residence in France, which is the embassy. A business address. That's my case. You have a private home. I don't have a residence. I have a private home. See the use of the words?
Richard, back up just a second there, where you said that that in that fourth admission on the IRS, that the Attorney General was enforcing executive.
Right. He works directly for the executive department.
So I didn't get the punchline.
That's it. He works directly for the executive department. He's only working for the District of Columbia, who's under the thumb of the president.
Oh, okay.
You said that code enforcement doesn't apply to private homes. Is it code enforcement, who handles the dog license?
because one of my drivers today was complaining to me, and I said, well, come to the meeting, and if you want some help. He's come by and he said, well, they said I either had to get a dog license or they're gonna take my dog. And they told him that.
Well, I'll tell you a little story on that. I'm glad you brought that up. This is a true story that happened to one of my preacher friends. I'm trying to think of his name. He was over in Middletown. He has a non-registered church, okay? He came to me and he says, the dog catchers came to my house and they want me to get a dog license. They cited me. I have 3 dogs and they cited me 3 times. I got 3 tickets. How do I beat these? I said, I ain't got the vaguest idea, but I'll tell you what to do. Because I never worked dogs. I worked cars. I says, well, if I was gonna do it, the first thing I would do is I would go get their dog licensing statute and start referring back at the bottom of each section of the law. It says, refer to section such and such, came from such and such, okay? Then you go back that one and refer to such and such. And you follow all the way back to the original intent of the law. So he did. He followed all the way back to 1905. It was the first time they ever licensed a dog. And there it says, which has never been overturned, they just left the terminology out. It says, this dog licensing statute shall not be enforced unless there's a complaint from 3 sheep ranchers that wild dogs have been attacking their sheep. And there must be 3 signed complaints. That's in LA County. That's what LA County's ordinance came from. So he went over to Baldwin Park. He was from Baldwin Park. He went to Baldwin Park Mini Court. He walked in there. He says, Your Honor, he says, you have those 3 signed complaints. The judge, what 3 signed complaints? He said, this licensing ordinance is invalid until you have 3 signed complaints. I just came from the law library, and I do have extra copies here of the ordinance I just Xeroxed for you. Ma'am, would you give this to the judge? And the judge looked at it and says, you're right. Sir, you've done your homework, case dismissed. Never told the audience what he was doing.
Well, maybe I misadvised him, because when I went back there this afternoon, I said, well, here's what I can think of immediately, and I gave him a copy of my no trespassing sign I just silk screened. I told him, put this on your front and back gate, and when the code enforcement officer comes knock on your door, call the police. Because he just trespassed, and that's gonna have to do him over.
That's one way, but if you want to beat the ticket, you study the law. How many times have I told you to study the law before you do anything? You don't deal in emotion. There's no room for emotion in the courtroom. But study the law. And every law is the same way. Every single law they wrote, if you go back and research to the very beginning, only applies to a very specific thing. In fact, Simi Valley Code Enforcement, I got a copy of their rules and regulations for Simi Valley. And all their authority they talk about in their court cases are commercial use only. Commercial use only. Commercial building. Commercial builder building contract tract homes. You follow me? Commercial building a 4-story office building. You follow me? Everything for sale. Commercial use. Not one time of those court cases that they cite concern a private home. And I can't remember, but I'll give you the quote. I want you to write this down. A case is not authority for a proposition not contained. A case is not authority for a proposition not contained. I've got 50 to 100 sites on that. In fact, Julia, you read a couple of those. Reason being, if this case talks about a commercial building and you have a private home, this doesn't relate to this. It's distinguishable, it doesn't apply. It's not authority. If this talks about case about a woman and you're a man, it doesn't apply. Say it's a woman thing, okay? Or if you're a man thing and it talks about a woman, it doesn't apply. You know what I mean? If it talks about an automobile, in this case it's about a jet airplane, you follow me? It doesn't apply. Two different animals completely. I just had an interesting thought. Steve knows how dangerous I am when I think. What would happen if you went over to Burbank Airport and as the plane was taxiing down the runway, you had the police officer go out there in a squad car and have them cite the airplane for exceeding the speed limit? An airplane's a motor vehicle, isn't it?
They're registered.
And it's registered. And the speed limit in California is 30 miles an hour, and if he gets to take off, he exceeds 30 miles an hour, he can be cited.
On private property, right?
No, that's public property.
Well, there may be a better application than that. The question might be, Your Honor, if an aircraft is a motor vehicle and is registered as such, and is allowed to break the speed limit,
Am I allowed to make a speed
then
limit?
what is the ramification of that concept?
You see what I'm talking about? Interesting concept. But you have to think along these lines, you know what I mean? Hey, that's the way the law is written. So let's enforce the law. How many times have you, people in here have you say, if you follow their law and make them follow their own law, they will lose every single court case. It's impossible for them to win any court case. Because the law says they gotta go through that door and that door at the same time. Can you walk through that door and that door at the same time? And meet yourself on the other side of the building? That's what the law says. Their laws are so vague and ambiguous that it's impossible for them to win. If we could just force them to obey their own law, they could never convict anybody. It's impossible to convict anybody. And we do have that suit ongoing against, it's now in federal court, against the company, I'm not gonna name it on television, wherein the company refused to remove the Social Security number from the citizens because he no longer had that number. That number was obtained by his parents under fraud and duress. So we're suing the company and allegations of maintaining false records. And the corporation could lose their license, corporation license in California if they're convicted of a felony.
Are you gonna list his parents as unindicted co-conspirators?
But here is the type of admissions that you would file in the, say you were gonna file a court case, and I'm gonna give you the law for it. It's Civil Code, Section 1798. That's the California Information Practices Act. See, the California Information Practices Act requires them to get all the information from the source. And who is the source of all information about you? You yourself. Not even your mother can tell about you. Only you can tell about you. Nobody else can tell us. The IRS agent sitting up in San Francisco, the FTP agent sitting down in San Diego, the mayor sitting in Sacramento, President Clinton, he may know something about you. He knows something about everything else. But you are the source of all information according to California information practice, as it relates to you. So they have to take your word over anybody else's. In failure to do so, the law says, the civil code says you can sue them. And that's why we're suing this company based on California law.
Section 198.
Huh?
What section?
1798.
1798.
1798. And this is the type of admissions, you file a lawsuit, and 10 days after the lawsuit is filed, you have to do admissions. Okay, that's when you're doing a civil suit. But under a criminal, on a citation, you do it the next day. So I got all my admissions already prepared for if and when I get a ticket. I'm already prepared. Next day, the cop's gonna have a list of 30 admissions on his desk, and the prosecuting attorney's gonna have 30 questions on his desk. So you prepare everything in advance, because if you don't have a computer, you can't prepare anything. You gotta be prepared. Now, this is the type of admissions that you would do in in the civil matter. Admit that John Cecil, Slavedomore is the source of all personal information about himself. They have to admit that. Admit that on 6 June 1995, John Cecil, Slavedomore sent you a letter telling you to correct the records that are maintained by you. They admit that you sent them a letter. Admit you have not corrected the records as per the letter dated June 6, 1995. Admit that it is a crime under state and federal law to maintain false business records. Admit that under California Government Code Section 1798, it states that all information should be obtained from the source. Admit that you are obtaining false business records by your failure to correct the personal information submitted by me. They're gonna deny them, they're gonna do everything else. In your case, they didn't even answer, did they?
Yeah, they said they were all vague and ambiguous.
Yes. Now, that's a vague and ambiguous statement.
They said the admissions were vague and ambiguous?
Yeah, those I just read you.
Can they do that?
Sure they can do it. But then you will go to the judge and ask the judge to compel them to answer it. See, they're just stalling for time is all they're doing. Do you know when you register your car, you give California takes a vested interest in your car? And Attorney General of California already has published an opinion to that effect. This is California AG opinion, 97-202, dated June 9th, 1997. Repeating, 97-202, dated June 9th, 1997. That's opinion of Daniel E. Lunger. They have a vested surety interest in your car. They are the bailee. That's why they can impound your car when you register it. And when you register your car, if you read the last, on the second page, when you just above your signature, let's see, did I put it in this bag or not? It states right there, you agree to hold the state harmless for anything they do. For taking your car. See, I'm going right here, Pat. Yeah, here it is, statement of facts from the DMV. This is, let me read this. 256. California registration form, statement of facts, 256. Where's the reverse side of it? That's the front side of it. But that's a form, and that's the back side. It says it's a two-sided form, and on the back side, you agree to hold the state harmless. I'll read you the terminology that you sign when you register your car. I further agree to indemnify and save harmless the Director of Department of Motor Vehicles, State of California, and subsequent purchasers of the vehicle or vessel for any loss suffered resulting from registration of the vehicle or vessel in California, from issuance of a California certificate of ownership covering the same, or transfer to. And they will not register your vehicle unless you give them the bill of sale or the manufacturer's certificate of warranty. You must give it to them. They won't take a Xerox copy. They want the original with your signature or the buyer's signature so they can put it on their computer so as security for the federal debt. Excuse me 1 minute here. Got a little cold. Okay, and next case I'm going to talk about. This is, how many people have sent back their driver's license and had it canceled? A few, okay. This is the California Court of Appeal, 4th District of Texas, opinion, dated August 6, 1997. In it, the court held that if your license is canceled or not valid, they can't suspend it. You can't be convicted of driving on a suspended, they can't suspend something that does not exist. Which their law reads just like ours. This is what it says basically. To obtain a conviction under this statute, the prosecution must show either that the accused had an unexpired license which was suspended at the time of the alleged offense, or the accused's privilege to drive was suspended at or before the time his license expired by its own terms, and that the privilege remains suspended from the expiration date to the time of the alleged offense. They have to prove that it expired, was suspended before it expired. If it's expired, they can't suspend it. Yes?
Is that the term that I want to use, canceled? I canceled the license, or would
Right, you
rescinded be
canceled it.
better? It's better than rescinded?
Yeah, canceled.
Canceled.
It's
So I
not in their
canceled it.
terminology.
Okay, good.
See, they can't suspend something that doesn't exist. That's what the court feels. And this is, of course, from Texas, and reversed and acquittal ordered not to be published. They don't want people to know the truth. All the good cases are never published. No, it's not. No, they're protecting their own. When I got this, I got it from a friend of mine down in Texas. Then from Cal, he faxed it to me because he's one of my people I work with. So he found this case because he knows the guy personally because he's helped him. And then he faxed it to me here, and I faxed it to my friends in Texas. I faxed it to Jeff, and Jeff down in Texas. How'd you get this? He says, you're in California. How'd you find this case? It's not published. I said, I got friends you ain't. See, you can use the same type of terminology, you know, and just paraphrase it slightly, you know what I mean? And do your argument. And here's another California's attorney opinion. I have to thank Steve for this one, and the other one both. This is Attorney General Opinion 96-1201. I want you to read it. It's got a lot of good things. says, a peace officer may arrest a motorist who has committed an infraction, i.e. driving to the left of the double unbroken line or traveling, and even though no accident, traffic obstruction, or other event has occurred. Notice the key words, may arrest. Let's stop. A peace officer may issue a notice to appear in court to a motorist who has committed an infraction. If a motorist is stopped for committing an infraction and refuses to sign the notice to appear in court issued by the peace officer, the officer must take the motorist into custody. It's expired already. It's April 25th, 1997. Not even a year old yet. A magistrate is not required to be on duty in the county at all times, but must be at all times be reasonably available to call out, on call, to perform official duties. In other words, if you demand to be taken to a magistrate and it's 10 o'clock at night, they have to call him out and bring him.
They laugh at you.
Huh?
They laugh at you. 2 days in county, then you get to see the judge.
But read the opinion, you know what I mean? Get it off the internet. And the internet address to obtain this is http://caag.state-ca.us/opinions.
If you
What
just-
happens after CAAG?
If you just put California Attorney General into a search engine, it'll bring up the homepage.
Yeah. So put California Attorney General in, you know, like click on the search button there. It says search, you know, right at the top on your browser. Click on the search and it automatically came in. Okay, if you, let me repeat it. CAAG dot state, STATE, dot CA dot US /opinions / and that'll take you right to the opinion page. And if you want to use a good web search engine, which I use all the time now, I was up on it 3 times today. It's www.lawguru.com. I like that one better than I like the other one. I used to go to Mother, you know what I mean? www.lawguru.com. GURU.com. It's based in Florida, and they have links to every state in the union and every state's cases, every state attorney general opinions, all the laws, and all the state statutes. I like to keep my bookmarks down cheap, you know what I mean? Small as possible. So I've been using that one. It's so easy, you know what I mean? You click on it when the top box comes open, what do you want to do? And you just click on the box and it drops down and says states. You go down to California, click on state California, go there, bingo, you're there. And it breaks it down for you, whatever you want to go. When you go federal government, you get the IRS code up there and everything else. CFRs and everything right there. If you got environmental laws, you can get your environmental law protection there also. See, the internet is very, very good for researching the law. Especially the newer laws, you know what I mean? Because they change them on a daily basis. The older laws, they can't change.
They just call them old and ignore them.
Yeah, they expire. Okay, let's take a break for about 10 minutes here so I can take a quick break here, and then we'll be right back because I'm talking very fast because I got this much more to go, and I got this much more to go. About 4 inches of stuff to go through here because I missed last month because I had to leave because of my flood. traffic signals, if you wanna really fight and argue, which I like to do, all traffic signals, you know, these blinking lights and these red lights and the green lights and the speed signs and everything, they're all for interstate commerce. And it's the MUTCD, write that down, MUTCD. You get that from the internet also. That's the Manual on Uniform Traffic Control Devices, MUTCD. See, with the law in your hand, you walk into court, say you get cited for running a stop sign. This is the left-handed argument, okay? I like doing left-handed legal arguments, legally correct arguments. The officer's there, he says you ran a stop sign. You don't address the issue of the stop sign at all. You never claim you did do it, you never claim you didn't do it. And the officer gets up on the stand. Hey, officer, I only have one question. Was I involved in interstate commerce at the time you alleged I ran that stop sign? You said, no, you were in your car. Thank you, officer. No further questions. Your Honor, I'd like the court to take judicial notice that traffic stop sign is in compliance with the Manual on Uniform Traffic Control Devices published by the federal government for interstate commerce. The officer admitted I was not in interstate commerce, and therefore, since I was not involved in interstate commerce, I could not have run that sign. The sign doesn't exist for me. Steve, I'm doing your argument.
I hope you're doing it well.
Steve wants to try this argument, interstate commerce argument. I'll back up and repeat it again, so Steve's here. You get the officer on the stand, he allegedly stops you and gives you a ticket for running a stop sign. The officer gets up on there, and officer, I only have one question for you. Was I involved in interstate commerce at that time?
Objection. That's what they're gonna do.
Then, Your Honor,
Relevance.
the relevance being that that sign complies with federal standards under the MUTCD, and I'd like the court to take judicial notice. I have a copy of it here, and I'd like the court to take judicial notice that traffic sign is for interstate commerce. And the officer, if I was not involved in interstate commerce, I'll let the officer state so. That's all it is. That's the only question I have. Or you can ask the officer, officer, does that sign comply with the Manual on Uniform Traffic Control Devices? You say, well, I don't know. Thank you, officer. That's what he's gonna say, I don't know. Thank you, officer. Your Honor, I'd like to subpoena the traffic engineer from LA City and have him step up and testify that that traffic sign complies with the Manual on Uniform Traffic Control Devices. Because if it doesn't, it's not any good. If it does, it's still no good. Either way, you win. Yes?
Is this a traffic signal or a stop sign?
Either one, stop sign, either one. They all must comply with this. So once they comply with this, that's admission that that sign relates to interstate commerce.
Officer, before you stop me, did you have any prior knowledge that I had come across state lines as interstate commerce?
Would you describe the last encounter you had in a traffic stop and the conversation that ensued and what happened? Do you remember?
No, it's been so. Oh, the last one. Oh, the last one time I was stopped by a cop was a week after I got my last ticket. LA County Sheriff stopped me and stopped me over on Box Canyon Road but it had no plates. And I stepped out of the car, and he said, I stopped because you don't have no plates. And there was two of them. It's pitch black there. There's no street lights. It's dark over there. There's no lights at all. They're over like this with lights on me. And
A black man would have stayed in the car, by the way.
so I got out. It was fall. It was in December 22nd, 1990. And I stepped out of the car, and as I stepped out, I opened my jacket like this. I said, I'm not armed, and I mean you no harm. He said, oh, okay, just like that.
But I'm dangerous.
And he said, I stopped you because you don't have your plates. I said, that's right, I don't. I said, send them back to DMV. I'm trying to get plates from them, but they won't give me one. And I'm trying to fight with them now, and we're going to be in court over this battle. He says, you're going to be in court over this? Have a nice day. I don't want to be bothered with you.
Married.
See, they don't like to be summoned in the court, you know what I mean? Especially when they work out of Malibu and they have to come all the way to Van Nuys. That's a long way to travel just to make a court appearance. Because if I'm going to take them to court, they're going to be there 3 days. Guaranteed minimum 3 days. But see, if you put MUTCD on your search engine, on the internet, you know, click on the search button there and put MUTCD, it'll come back with this. Very, very simple.
Richard, I'm not convinced. So I want to ask a question on this argument. I don't understand where compliance with the MUTCD implies exclusivity to the argument about commerce.
Because every traffic device and every sign, anywhere across the nation, without exception, has to conform to those standards.
Fine, but that doesn't mean that it exclusively applies.
Yes, it does.
Okay, where is that argument?
Where would the federal government get the authority to make a demand like that across the board if it were not interstate commerce?
It only applies through the Interstate Commerce Clause.
Well, what about rules of the road?
That's beside the point. These are not rules of the road. These are traffic devices for interstate commerce. That's what it says in here.
Okay, so you're just arguing on the device question alone,
Device question only.
not the rules of the road.
No.
Okay, got it.
See? There he's trying to stretch my argument out this far, and I'm trying to keep a real narrow argument.
You gotta watch it like that.
Got it.
Yeah. Everybody has heard about the Frank R. Bruce-Shaper case. You know Bruce-Shaper? But nobody ever did the argument right. To this day, and I started researching in 1981, and that's 81, that's 17 years now. Not one single person across the United States, and I've talked about this many, many times. My friend Mitch Modolewski published it in his book, The Federal Zone, and nobody, let me repeat, nobody has done the argument right. It can be won. The first sentence of the pleading out of the United States Supreme Court, you give the court, you submit this, a copy of this, and have the court take judicial notice of the pleading of the political status of Frank R. Bruce-Shaper. This is what it says. Frank R. Bruce-Shaper, a citizen of the state of New York and a resident of the borough of Brooklyn. He was a state citizen, and he was receiving income from Washington, D.C., the United States. And nobody ever brings that argument up and distinguishes which United States you're talking about. They're talking about the singular, not the whole nation. He was receiving income from railroad bonds that was chartered by an act of Congress. It's income from the United States. Nobody's used that argument yet, and I bet I've mentioned this at least twice a year for the past 5 years. I've been coming here since 1989, doing seminars since '89. And at least twice a year since '89, I've been talking about this, and nobody across the United States has stopped and thought and read what I said. Go look it up. Frank R. Brushaber case. See, if he's a state citizen and he's receiving income from Washington, D.C., and you're a state citizen in California, and you're not receiving income from D.C., difference, isn't it? TD 2313, Treasury Decision 2313 was derived from this. Yes?
I am trying to get in touch with the man who wrote the Fed Zone because I wanted to buy the book. And his address on the internet is no longer valid. My mail came back.
I don't know where he moved again, you know what I mean, so I don't know where he's at.
Yeah.
But I have a copy on my BBS number's there.
Yeah.
And
Actually, what I did was download it from the
Internet.
I stole it, is what I did. I just downloaded it.
Yeah, I have it on my, I had, he gave it to me right after he did volume, number 4.
Yeah.
And he gave it to me and I put it on BBS.
He's got a lot of good stuff in there.
Yeah, it's all right there. But nobody's done the argument right. They all deal in emotion over here rather than go back and let them prove otherwise.
He's a smart guy. He moves around a lot. He's trying to avoid having a suicide or a plane crash. Yes,
But sure, the Brushaber case had to do with, unless I'm confusing, had to do with the Supreme Court ruling that income was corporate profit.
Yes. And they did Treasury Decision 2313 out of that. And that's what they're complying with right now. And that's what they use against you.
But Brushaber didn't have any corporate profit.
Yes, he did.
Oh, he did?
He had railroad funds from, he was receiving stock dividends from Washington, D.C. From a Washington, D.C. Congress.
Source of the income, United States.
So corporate profit does not literally mean that if you have a corporation and you have a profit.
No, only if it's from Washington, D.C.
I've been arguing correctly then, totally by mistake, okay.
See, but nobody wants to go back and research the law. I've had this problem many, many times. That's what I do, is I try to teach people the law. Remember we were talking earlier about the state constitution being superior to the federal constitution? Now, listen to what the California courts have to say. Write this site down. California versus governing. California versus governing. 53 Cal Reporter 2nd 474. 53 Cal Reporter 2nd 474. It's an old court case out of Santa Ana in 1996. It's kind of old, you know, it's almost expired. Listen to what the court in Santa Ana said. State constitution provides protection for free speech, which in certain contexts exceeds protection provided by the First Amendment of the United States Constitution. So, the U.S. Constitution gives you this much, the state constitution gives you this much, which you want to use. And I got numerous court cases that say the United States Constitution is the floor of your rights. And the ceiling is the state constitution. Which you're going to use, the ceiling or the floor? Because they can trample on the floor, but they can't trample on the ceiling. I haven't found anybody who can trample on the ceiling yet. That's what the court said. That's their terminology. Remember that court case, Steve? It says, The rights protected by the federal constitution are the floor, the basis. And the rights protected by the state constitution is the ceiling. It's unlimited, in other words. Now, listen to what the court said about, this is the United States Supreme Court. The purpose of the United States Constitution and Bill of Rights, unlike more recent models promoting welfare states, the 14th Amendment, was to take the government off the backs of the people. That's what the United States Supreme Court said in Schneider versus Smith. S-C-H-N-E-I-D-E-R versus Smith. 390 U.S. 17. Repeating, 390 U.S. 17. If the purpose of the Constitution is to take the government off the people, and the 14th Amendment is to promote a welfare state, which do you want? A welfare state or the government off your back? Yeah, you would. He said both.
All the freebies with no responsibility.
Yes. You sound like one. See, in doing research, lots of times when I'm doing research, what I do is I'll get a thought and I write these little notes to myself, you know, set it on the computer. If you don't have a computer, you're non-functional as far as I'm concerned.
My lady's far too functional.
What if you're Jim Ziegler?
Huh?
What if you're Jim Ziegler?
Even with a computer, you're
Right.
non-functional. He's your husband, of course, isn't he?
Right.
Okay. He's my friend. Before I get to this, I have to tell the story. Since Jim's not here, I can do it. Jim's my friend for years and years and years. So one time, bought a computer and I gave it to him. He hates computers, so he put it in the closet and put a blanket over it. 3 years later, I asked him, I says, have you ever turned the computer on? He says, no. He said, I'm afraid to open the closet door. Then he finally got one. He finally convinced him, so he bought one, you know what I mean? And now, for a number of years, he wouldn't go even to the grocery store without putting the computer in the back of his car and take it with him. He was that attached to it. Steve here, took me 6 months to convince him to buy a computer. Now he said he'd rather give up his dog than his computer. In fact, he'd give up his gun, his house, his wife, his car, everything, not his computer. But see, I put these little notes down to myself on the computer. This is a theory I'm trying to put together. It's one size fits all. I was reading court cases, and when I read a court case, I come up with an idea. And so I jotted it down. The Department of Motor Vehicles, by using the policy of one size fits all, has created a disparate impact which is unconstitutional. The United States Supreme Court has struck down numerous laws that are based upon the disparate effect of the statute. Moreover, the absence of a malevolent motive does not convert a facially discriminatory policy into a neutral policy with a discriminatory effect. It cannot be contested that the Department of Motor Vehicles will only issue a license to those who admit to being a, quote, resident, quote, in California. It also cannot be contested that the state and federal government utilize the driver's license to establish that the holder is subject to all the state and federal laws establishing that the holder is a citizen of the United States under the Protection of Interstate Commerce Clause. See Hendricks versus Maryland. See, they use that driver's license against you. 2, the courts have held that an employment practice involves disparate treatment, though explicit facial discrimination does not depend on why the employer discriminates, but rather on the explicit terms of the discrimination. In Martin